Welcome to another in our webinar series, AML RightSource Voices. I'm Elliot Berman. I'm an AML BSA Thought Leader here at AML RightSource, and with me today is Chuck Taylor, our Executive Vice President and Head of Financial Crimes Advisory. In this edition, we're going to be focusing on cannabis. We will be talking about the current state of the law and regulations, what's changed recently, and how financial services companies can operate or prepare to operate in this environment. Chuck, I think any discussion on this topic really starts with the background. What are the laws that put us in place? And I think that discussion starts with the Controlled Substances Act. Much of the challenge that financial services companies have faced, and others too, of course, is that cannabis, other than hemp, as we're going to discuss a little later, is a Schedule I controlled substance, so that with that current classification, activities surrounding cannabis are all criminalized at the federal level. There have been several bills introduced to declassify it as a controlled substance, including just last month, the Marijuana Opportunity Reinvestment and Expungement. They did all that to get to MORE Act.
I think they come up with the acronyms first.
Right, and then work backwards. Yeah. That was approved by the House Judiciary Committee. It has not come to the floor yet, and I'm not aware of any similar action in the Senate to this point. So that's our starting point. The next point is that the states have taken a lot of independent action. 33 of them, plus the District of Columbia over the last number of years, have legalized marijuana for medicinal use, and 10 states plus the district have now approved it for general recreational use through a variety of licensed sales outlets and things like that, which is not our focus today. But I know there's been a recent change as it relates to hemp. Can you tell us about that?
So just to roll back a bit,
sure.
It's really interesting that we get to do a discussion and send it out to the world about violating federal law. Right. I mean, the gist of a lot of the things that we're going to talk about today are ways that financial institutions can, hopefully successfully, if they want to, take on these types of business, right? Folks that are growing hemp or state legally dealing with medical or recreational marijuana, and a little level setting as well. It's tough for me to do these types of things because we don't have an audience reacting to us. We do have the opportunity to send questions, so I want to make sure that everybody that's listening in today sends us any questions. You signed up for this for some sort of reason. I know this is a hot topic. Many of the things that we're going to talk about have been talked about ad nauseum by different folks. There are so many places you can go to get information on this stuff. I'm hoping we're going to, give you guys that are listening in a little bit of opinion, a little bit of things that, maybe are different opinion on some of these things, and hopefully try to help you with stuff. And again, kind of level setting with the Controlled Substances Act, you started there, and I've always found it interesting that, marijuana, and then one of the things that throws me off on this a lot, and I'm getting off on a tangent, but you hear cannabis, you hear hemp, you hear marijuana. I read something recently that explained it the best to me in that everything in regards to this is cannabis until it's tested, right? So the cannabis plant has different strains, different types of cannabis plants have been enhanced for different things, right? So it's all cannabis. Once it's been tested, if it's less than, or if it's 0.3% THC or less, then it's hemp. If it's more than that, then it's marijuana, and it's illegal. So that explanation to me kind of is a good level set. I don't know if it's a perfect explanation, but it really makes sense to me and kind of drives it home. And then the Controlled Substances Act, back to that, it's still interesting to me that marijuana is a Schedule I narcotic, right? Cocaine is a Schedule II narcotic. And if you read the reasons why things are Schedule I, it's because they really have supposedly no medical value and they are easy to abuse, right? And I think there's so much information out there about the medical use for marijuana and that kind of thing that I'm hoping at some point all of this stuff that we're going to talk about goes away, and that the government decides that it really doesn't need to be Schedule I kind of like the MORE Act that we're going to talk about a bit, that it needs to be delisted, and then I think a lot of this goes away. But I'm getting off a little bit on a tangent, but back to hemp, right? So with the passing of the Farm Bill, it deschedulized, if that's a word, the cannabis plant as long as it is less, 3.3% or less of THC. And the good thing about that is that folks that are dealing in that type of business that want to cultivate hemp now can do that legally. The problem is that there are it's still uncertain because the USDA has put out interim guidance, right, that says we're going to license things, and when states come up with their programs, they can send us their programs. We will decide whether they're meeting our guidance or not, but they haven't really said what needs to be in those. They've given some guidance in the interim rule, but that might change because they're still open for comment and that kind of thing. So we get questions all the time from our clients that want to jump into that space. It appears to be the type of space where there's money to be made as a banker. You can bring folks on, and there's all sorts of hype around it these days. And one of the issues, I think, is that the hype around all of it has made all sorts of folks jump in and invest in it. And then in economies like in California, where it's a $3 billion cannabis economy, many of the companies are laying off people and that kind of thing because the supply chain hasn't worked out and the demand maybe isn't working out and all that kind of stuff. So I'm trying to level set the beginning of the conversation, and that's kind of the state I see it. There are all of these things that have come out. The guidance from FinCEN and the regulators about banking folks in the hemp industry. Did that really help us in any way? I don't think so. All it really said is that you don't have to file SARs on the hemp folks anymore. But your thoughts?
No, I think that's exactly right. So I think you're referring to the 2014 FinCEN guidance,
right.
And they issued that because in late 2013, the Department of Justice, the then Deputy Attorney General James Cole, issued what's become known as the Cole Memo, and it talked about a variety of prosecutorial guidelines to U.S. attorneys around the country, right, on how to prosecute certain types of activities related to marijuana. And in fact, it was entitled Memorandum for All United States Attorneys, Guidance regarding Marijuana Enforcement. Following that, ideally to help the banks, FinCEN put out its guidance. Then in 2000, I've lost track of when it was, in January of 18, the now Attorney General rescinded the Cole Memo.
Former, right? Mr. Sessions.
Oh, you're right. I beg your pardon. Yes, you're correct. Yeah, yes, you're correct. At that time, it was Attorney General Sessions,
right,
correct? And then, and more recently, current Attorney General Barr has issued a statement, a short statement about the Cole Memo topic, essentially saying, I trust my attorneys, my state's U.S. attorneys in the various districts to use appropriate discretion, which is fine. But to the extent that our customers and and the financial services industry wants to decide whether or not to get into an unclear area, clear guidance is helpful, and right now there isn't any clear guidance.
Yeah, I think the only thing that you can really use as a financial institution these days to kind of guide the risk assessment that you're doing if you want to take on, legal or medical marijuana businesses is that 2014 guidance from FinCEN. So Sessions rescinded the Cole Memo, but that guidance took information from the Cole Memo and basically implemented it and said, follow these rules. Things like, you shouldn't allow these companies to sell to minors. Make sure that they're not getting their product from illegal sources, all that kind of thing. And the rescinding of the Cole memo didn't rescind the FinCEN guidance.
Correct.
And then so Barr has now said, basically in simplest terms, I'm going to roll with the Cole memo. And so as long as people are abiding by that with state legal businesses and following the state licensing requirements and all that kind of thing, it doesn't make sense for federal law enforcement, U.S. attorneys and such, to bring cases against folks like that. So I think that's kind of the state of where we're at. And if, I'm guessing many of you folks that are listening right now hear about the hype, hear about other banks that are taking on these types of businesses. So that's where I'd recommend starting, right? Looking at that guidance from FinCEN, making sure that you're comfortable with everything in there. If you were going to take on a business that is state legal, are they following all of those things that it says in that guidance? Can you prove that they're following those things? If you can't prove them, I mean, some of them are conceptual, right? And some of them you'd never be able to get proof of whether they're doing them or not. But as long as you can get comfortable with that and build a program around it, then it's probably unlikely that you are going to be prosecuted as a financial institution for taking those funds, even though you're technically laundering money, right? It's proceeds from a federal crime. And even though potentially the client that you're taking on is doing everything in a state legal way, it's very unlikely that there's going to be any sort of a case coming and saying, hey, Mr. Banker, you are facilitating a federal crime. Because you just don't really hear about state legal businesses getting in trouble for doing it the right way, right? The cases that you hear about are folks that have a state license, but they're violating one of those things in the FinCEN guidance, or they're getting their product from an illegal source.
Right.
That kind of thing. So I think that's where we're at on that guidance.
Yeah. I just want to go back to that one detail in there. You talked about, doing the kind of due diligence to do an effective risk assessment. I think it's important to understand that when a financial services company enters into any new line of business or starts providing services that they've already provided but to a new business sector, you really need to become very knowledgeable about how that sector works. And it's easy to make a lot of jokes about, well, we've got people who have smoked marijuana, so we must know about the business. But the reality is, it is a business. The state licensed sellers or dispensaries have a protocol they have to follow to be in business, and really understanding what those protocols are state by state, particularly if you're in a multi-state environment, is really important. So in making that risk assessment judgment, is it within the risk appetite to try to do this? The knowledge base of your institution, either that you had in-house or that you build in-house going into this is part of that issue.
Yeah, I mean, on some level, it's not really any different than any other high-risk type business that your financial institution is wanting to get into, right?
Correct.
When I was a BSA officer, we would sit in it had a funny name, but it was basically our BSA committee, where we would talk about interesting clients or new regulation or new segments that we wanted to get into. And it would be, MSBs. And then there was the crypto craze. So we did a risk assessment on how we could successfully bank folks that are, directly in the crypto business or investing in it or whatever else. So it's not really any different in this case, right? The only difference is that cryptocurrency is legal. And technically, marijuana isn't.
Correct.
But as long as you can get over that hurdle and say, okay, as a financial institution, we're willing to launder money for this state legal business, whether it be hemp or marijuana, then it's kind of just figuring out how to do that. And then my mantra, if you've ever heard me talk about stuff before, it's all about what are you willing to defend to a regulator, to law enforcement, to your board of directors, all that kind of stuff. And if through the risk assessment that you do that we're talking about, you can't get to the point where you feel like you could successfully defend that program to any of those parties, then why would you do it, right? Even if it's going to make the institution a lot of money. In preparing for this, I reached out to folks that I know that are either banking direct cannabis businesses on some level, or really embedded in kind of what I'd call tier 2, where they're getting money directly from those businesses. It's all about just getting comfortable with that and building a program and figuring out the best way to manage that risk, right?
Yes, I think that's a perfect construct for it. So let's shift gears a little bit. We've touched on some of these, but let's talk a little bit in more detail about some of the recent changes. So first, let's go back to the hemp and you mentioned that the 2018 Farm Bill was passed, and then that USDA, which actually regulates this piece, passed an interim or issued an interim final rule. Interim final rules are kind of a flip-flop. You've got a final rule that's in effect, and then you have the comment period. And then the idea is that the regulator, in this case USDA, will collect all the comments through the normal comment process, and they will come out with a full final rule, possibly not changing anything, possibly making changes based on the comments or other input. So talk a little bit about the, kind of where we are in that process and what that means. And this is hemp, less than 0.3%.
0.3% or less.
I'm sorry. That's right.
To make sure on that.
0.3% or less THC when it's tested. So, and there's been, just for everybody's knowledge, there's been an industrial uses for hemp forever. Going back.
Sure.
Every pirate movie you've ever seen, the ropes were made out of hemp, or at least were supposed to be.
Right. And just to touch on the percentage, right? There's information in the guidance that's out there that there's a margin of error, right? So the guidance says that it has to be 0.3% or less, but there is some guidance somewhere, and it's escaping me at the moment. But the thought is that if you're at 0.5%, then you're almost negligent, right? Because that's more than a margin of error. If you're at 0.35 or 0.4, then you're probably not going to have an issue with that, although you have to then destroy that because it's over 3. But when you get into negligence, right, you say you're growing hemp and the intent is to keep it at 0.3 or less, and somebody comes in and tests it and you're at 0.6, you're not doing it the right way and you don't have the right controls in place. So then there can be an issue because you're technically growing marijuana, right? So in regards to the USDA and the guidance that's out there now, just some things that are in it, when the states are creating their programs to abide by this and then get approved by the USDA, you have to report the land that's in use, and that's not any different than many other crops you have to do today. You have to report, I have these acres at this GPS location, and I'm growing this type of thing, so the states need to keep track of that. There has to be a testing process in place with a DEA registered lab, and the reason why it has to be DEA registered is because of the thing I was talking about before, right? If they're testing it and it's more than 0.3%, then it is marijuana, and the DEA wants to be involved in that kind of thing. So that's the reason for that. Excuse me. You have to have guidance about disposal, about compliance with all these regulations and things that are putting in place, information sharing with the USDA, and then certification of resources to comply with all that stuff, right? So I'm trying to get my license. I say I'm going to do all this stuff. I have to be able to prove that I have the manpower in place to deal with it all. So it's the guidance is out there. Like you said, it's unlikely to change. Things do change, though. Mm-hmm. If you think about the beneficial ownership requirements, when the interim rule came out, there was a lot of changes by the time that the actual rule was put in place. So I guess my point here is, the states could build programs that meet all of these requirements. The USDA gets some comments in that totally change it, right? And add some things that are burdensome. Then it kind of takes everybody a step back. And maybe you've jumped in and you're banking folks that are legally producing hemp. But then once the final rule comes out, then that state program doesn't get approved because it doesn't meet the USDA requirements. And then now you're kind of back to square one, and there isn't really a good way to make sure that all of that kind of future stuff is going to come into play. So confusing, yes. I think that's the point of all of this, is that it's just confusing. And it's back to, if you're going to jump into this space, and it's going to be our mantra through this, I think, is do that risk assessment, figure out the best way to do it. Can you defend the program? Are you comfortable doing it? That kind of stuff.
Yeah, so earlier this month, on the 3rd, the federal banking regulators, FinCEN and the CSBS, representing the state bank regulators, did issue a statement clarifying the obligation of financial institutions to file SARs for companies that are solely involved in the production of hemp. It was in the total picture of things, it was not a big announcement really, but it is, again, if you've chosen to go into this space, you need to understand that the SAR obligation has changed a little bit. Changed in your favor, I would say.
Right,
so,
it doesn't alleviate the need to still file SARs if there's something else going on.
Correct.
Right.
Correct. It's not a blanket. It's
right.
Really, it's very, this release from the obligation is drawn narrowly.
Right.
Yeah.
And then in reading that, when the thing, everybody has the alerts that pop up from all the regulatory agencies. I saw this thing pop up and it said, guidance on financial institutions banking the hemp industry. I'm getting the title wrong, I think. But I was like, sweet, something cool's coming out.
Yeah.
And then you read it, and it basically says you have to do CIP, you have to do EDD, you have to have monitoring, you have to file SARs, you have to file CTRs.
Yes.
Okay, we already knew all that.
Yeah.
You don't have to file marijuana limited SARs on these folks anymore, like you may have been doing. But that's kind of it. So I think it was anticlimactic for me, at least.
Yeah. The headline was way better than the article.
Correct.
I guess in this case.
Yeah.
The other thing that's happening right now is that in September, the House of Representatives did pass the Safe Banking Act, so that's Secure and Fair Enforcement Banking Act. That acronym and name work a little better than the MORE Act. And it has gone, it's being passed by the House. It's now at the Senate. There's been no hearings in the Senate on the passed bill. And there's therefore, of course, been no floor action.
We're going to get to that.
Okay. What the Act generally does is it provides a safe harbor for FIs that provide financial services to legal cannabis-related businesses. And it does that by precluding the federal banking regulators from inhibiting or discouraging those services. So I think, again, that might be generous to call that truly a safe harbor. Because generally, safe harbors I think of a safe harbor as I'm actually immune effectively from prosecution for taking a particular act because I'm following the law. The act also no longer changes so that the proceeds of cannabis-related activity is not money laundering. Takes it out of the definition, because where they're operating in accordance with state law, basically saying, as Chuck mentioned earlier, it's not the proceeds from an unlawful activity. That's how they modify the definition. It provides immunity for the employees of the FIs that provide services to legal cannabis businesses from being held liable under federal law or regulation. It amends some requirements related to providing suspicious activity reports, and it adds protections for ancillary businesses providing products or services. So you have the suppliers, not just the suppliers of the actual marijuana, but security services, the lawn mowing service, the attorneys, the
accountants, all those folks.
Everybody. Think of a business and all the vendors it has. Those folks are all at risk of being paid paid from the proceeds of the sale of an illegal substance.
Yeah. I mean, the main point for me, number one, I think it's unlikely it's going to get any farther, right? It probably won't get past the Senate. But I think the upside is that it appears that folks at the government level are thinking about it. Yes. And the sooner we can get to something like this, I think is great. One of the main issues with the jumbled mess that it is today is that state legal dispensaries and such are just sitting on piles of cash. And they can't, in many instances, find banks that will take that. They're finding other places to use the cash and such. But if something like this passed, and then financial institutions would be more willing to let folks use cards or checks or whatever to get cash out of it, if you could just walk into the dispensary and use your debit card like you do anywhere else, that would make everybody safer. They wouldn't have to have armed guards at dispensaries and more safety features than banks do and that kind of stuff. And then many folks that are listening today aren't going to jump in and bank what I would call tier one marijuana businesses where they're actually touching the plant. But everybody that's listening, if you're at a financial institution, is banking somebody that is taking some money from one of these entities. And it could be as simple as, like we were talking about before, an attorney, an accountant, whatever. And many institutions that I've talked to are willing to take that on, right? It's technically a business that money that is tainted from an illegal act for some sort of state legal business is flowing through your client to the financial institution. And maybe it's an attorney that specializes in dealing with legal issues regarding banking marijuana, and they held themselves out as that, right? You can assume that much of the money flowing through that entity is going to be tainted. But many other law firms will have a very small practice, right? Yes. They've got 100 attorneys and 2 of them are specializing in this. So a small bit of that money is flowing through. Most institutions are willing to take that risk and kind of letting them layer the money through a otherwise legal business and then taking that money on, right? So my point is that I think it's a great step, but what isn't there? Because we talked about this before, and I don't want to steal your thunder, because I think it's the most important part.
Yeah, what's not there is a declassification from as a controlled substance under Schedule 1. So, right. And I mean, again, I'm not a great political analyst, but I think a big issue here is that many people in the Congress understand that. On the one hand, they want to give their state legislatures some credence where they've made this activity legal. They want to help the banks and other financial institutions, but they want to be able to say they didn't vote for legalizing marijuana, right. But not decriminalizing it presents problems because, again, we go all the way back to Attorney General Barr's comments about I'm kind of on board with the Cole memo even though it's gone, but also saying, but all my U.S. attorneys have discretion, and if you get a U.S. attorney who, for whatever reasons, finds a case that they feel would be appropriate to handle, they've still got the hook to an illegal activity.
Right.
So
we've got a question that came in that I want to address because it's based on something that I said, right? So here it says, please comment on the following 2 statements that strike me as contradictory. And I say contradictory stuff all the time, so this doesn't surprise me. Number 1, banking a cannabis business is money laundering. Yes. Number 2, banking a business if you can defend the act to law enforcement. Oh, bank a business. So I'm advocating, I guess, banking a business if I can defend that act to law enforcement. If it's illegal, it per se cannot be defensible. Isn't it really a calculation that you're highly unlikely to have to defend the act? And if that is the case, what FI is taking the risk, albeit highly remote, of losing its license? Point taken, right? I guess on some level, it's not completely legally defendable. You can't sit in front of a law enforcement person or a regulator and say, hey, we are able to bank this dispensary because it's legal. You just can't say that. My point is that if you think you have the right controls in place to deal with all of the guidance in that FinCEN memo from 2014, if you've done the risk assessment that we talked about before, if you're comfortable with the fact that taking on this type of business is going to expose you technically to facilitating money laundering, then you've made that business decision. You're likely going to make money at it, right? Folks don't jump into this business and then hope to, hope to not make any money on it, right? They're going to do this because you can charge these folks more money in many instances because they're bringing in more cash that you can count, whatever it might be. They're going to be a customer that's going to make money for the institution. So I'm rambling a bit, but my point to put a button on it is, with any type of high-risk customer, there is the possibility that they are facilitating money laundering, right? We're concerned about MSBs because they have a lot of cash. We're concerned about cryptocurrency companies because it's very easy to move money without knowing where the money is going. We're concerned about PEPs because there's the possibility that they've taken money from corruption and they're going to put it in your financial institution. So the difference in this is that, yes, it's illegal and you have to kind of come to grips with that. But with every other type of high-risk customer where there's a propensity or the opportunity to commit financial crime through that entity, you're again deciding whether to take on that risk, and you have to be able to and willing to defend that when somebody tries to poke holes in your program. When the regulators come in, they ask for a list of your high-risk customers. If you're banking one of these entities, it's going to be on that list, likely, because they're probably a high-risk customer, and they're going to ask you about it. And my point is, if you can defend your program and say, yes, I understand that this is technically laundering money, but, and that's a funny but, right? I kind of started the conversation by, hey, we're going to talk to people about how to technically violate federal law.
Correct.
But you have to get past that if you want to be in this business as a financial institution. And everything else is technically the same as another high-risk customer, right? The risk assessment, the controls, you're doing site visits, you're looking at their books. I mean, these types of entities are in the business of making money. They're going to keep books. They're going to, in many states, there's a requirement of seed to sale, where there's a barcode on the seed that you scan all the way through the process, and when the bag gets to the dispensary, there's that same barcode on it, and you're tracking it. So I'll stop rambling, but to answer your question, I think it is defendable based on the current environment, even though it's illegal, which sounds really funny. And I'm going to be misquoted on that, I'm sure, but we'll see where it goes.
I won't quote you at all. Then right, I won't misquote you. How's that?
Cool.
Yeah, so with the time that we have left, in addition to taking any additional questions that come in, we want to just share with the audience some things, some of which we've already talked about, but kind of, actionable things. So, if you're going to do this, how do you go about it? You just a moment ago went through, a good basic checklist, but there's a number of other things. So let's first start, again, to try to keep the pieces separate. Let's take a walk through how we would recommend a financial services company that wants to start working with a state legal hemp organization that's legal under the Farm Bill change in the definition in the Controlled Substances Act. How, if you were still in your old bank, how would you go about if someone in executive management said, Chuck, help me, understand this stuff. Should we be thinking about doing this? What would you do?
It's a great question, because that kind of thing would happen. If I was still sitting in that seat, I'm guessing this question would have already come up. And I would have gone through a similar process to what I did today to prepare for this. I would have looked at all the guidance. I would have looked at the Farm Bill. I would have looked at the USDA proposed requirements. I would have figured out, what types of clients would be wanting to get into this, right? There's a difference in having a great client that is in a otherwise legitimate business and wants to get into the hemp production business, you're more likely to work with that person than you are to somebody knocking on your door and saying, hey, Mr. Banker, I'd like to open an account with your institution, and I am in the hemp production business. So you need kind of guidance on those two types of things. I guess there shouldn't technically be a difference in that, but everybody that's a banker knows you're gonna do a little bit more and be a little more helpful with a current client that wants to get into the business, if they're a good client, than somebody brand new off the street. It's just tougher to get a handle on that person that's walking in the door than the person you already know and you already are comfortable with. So in simplest terms, it's doing that risk assessment, identifying the controls that you would put in place. With a hemp-related business, what type of activity is there going to be on that? In simplest terms, you would want to see that they are, paying rent for the land that they're using, or that they own the land that they're using. Do you see payments going or transactions going through the account for things like fertilizer and heavy equipment and packaging equipment or whatever it might be, stuff that makes sense? For a hemp-related business, cash I don't think would really be a part of the process, right? It's not like folks are walking onto the hemp farm and paying for stuff in cash. You're producing it, you're packaging it, you're taking the flower, and if you're going to be sending those to folks that are creating CBD oils and such from it, it's going to be going to those types of folks, and then you're going to get a wire or an ACH from folks that it makes sense. So with hemp, I think the difficult part is what we talked about before, where it's still in flux. The USDA has put out these interim rules, but who knows what's going to change. And, I think it's just as convoluted as the other side of the business, where it's marijuana, where it's more than 0.3. So that's my thought there.
Yeah, so I think I'd emphasize 2 points that you made. One is these are business customers, and the same set of analytics that you'd go through in looking at whether or not you actually want to do business with or help finance this particular line of business. You may be doing business with a customer, as you pointed out, an existing customer who you have a long history with, who comes in and says, we think it makes sense for us to expand into this. So presumably they're already in some kind of agriculture related or something like that. They're not a metal bender and they just heard that, oh, hemp's legal now, let's go do that. Well, you don't know anything about all of the manufacturing of it.
Yeah.
The other thing is to think about what skills you have in-house as you do this analysis. And again, if your institution or your organization is already in the agricultural products business, you have a leg up because you understand some of those economics and the expense and revenue cycles and things like that, which can be very different from other industries.
Yeah.
So now let's talk about. We've already talked a lot about marijuana. We know that without the SAFE Act or something else passing, it is an illegal activity,
right.
And so you've got to get management, the risk committee, and the board over the hump of, are we willing? There's a risk we can't manage away,
right?
But otherwise, I think it's the same things that you've already talked about.
It really is. Like so many other things, as bankers or as the BSA practitioners, you end up being kind of a de facto regulator, right? There aren't enough people in the government to be going out and testing these types of business is enough. So my recommendation, if you wanted to get into the marijuana side of it, right? You wanted to bank, say, potentially a dispensary. Take one on. Build your program. Take one on that you think is doing it right. Get a really good relationship with that. Make sure that they're with that business. Make sure that they're open. Make sure that they're willing to show you all their books, the processes that they have in place to make sure that they're getting their product from a legal source, all that kind of thing, that they have good controls in place. Because you're going to be pressed on that when somebody's looking at that file, and it's important to do that. One of the folks that I talked to that is in this space said they require these folks to have smart safes. I don't know if you're familiar with those, but many armored car companies are dealing with franchises where you got a McDonald's, they have a smart safe there. Any cash that comes in, they throw it into this smart safe that only the armored car guys can open up. And then Armored takes it directly to the Fed. So the bank would never actually have to actually touch that money. So if you're going to get into that type of business, maybe that's another good control to have in place, that the money's going directly in. I think we want to get to the FDA stuff a bit, because we have a question about products such as cosmetics and dietary, which I think is probably about CBDs.
Yeah, so go ahead.
We should jump into that just for a bit, because we don't have a whole lot of time left. So
Yep.
CBDs, I think, are the hot topic of the day. And I think the biggest issue is that if you're putting CBDs into something that is going to be consumed by a human, that is regulated by the FDA. And to date, I think they've only approved 3 different drugs, something like that.
That's right.
With CBD in it. So anything else that is out there, and I'm making an overly broad statement, I'm sure I'm wrong on some level, but if you have, say, a vitamin supplement and it is touting that it has CBD in it, and that is not approved by the FDA, then that's technically illegal, right? Anything that's an edible that you're putting into somebody's body, even a pet. I read today about CBDs for pets. That's technically illegal too, because the FDA hasn't approved that stuff. Anytime you're saying that something is, has a value that's an edible, that something's going into your body, some sort of a medical or vitamin or health value, then that's governed by the FDA, and they just aren't approving that kind of stuff. So when it comes to banking that type of thing, if you're banking the local liquor store and they have all sorts of CBD products on their shelves, then they are technically violating, FDA requirements, and then you have trouble banking that entity. So I think until all of this stuff kind of levels out, I think CBD is still a pretty tough business to be in. It's tenuous, right? The FDA is sending out warning letters to different types of entities that are saying, hey, you are producing this product and you're touting that it has some sort of a medical benefit because of the CBD that you're putting into it. We haven't approved that, and there technically could be some repercussions for that. So I think it's a tough spot to be in at the moment.
Looks like we have some more questions. You want to...
So regarding CBD, are there more products riskier than others? For example, the sale of oils and lotions versus edibles? Yes. So the way I understand it, oils and lotions, there isn't really any concern by the FDA because it's not going into the body. The problem is that where are they getting that CBD oil from? Is the CBD oil, does it contain more than 0.3% THC?
Right.
If it does, no matter what you're doing with it, it's still illegal. So the concern there is where are they getting the CBD stuff that they're putting into the lotion. But as far as I understand it, lotions and such are not a problem, but consumption of it is.
Yep.
Let's see, how would you know if a testing facility was DEA registered? I believe they can prove that to you because there's a registration. They can show you that they're registered. Will you be sending out the slides after the webinar? I think we will likely be posting them on our website, and we likely will be taking some pieces of this and publishing it. We're actually recording it, video recording. And any questions that come in after our time is up, because I think we're almost at our time limit, we're going to be making sure that we also answer those via maybe a quick video, some sort of a blog post, or at least posting them on our website. But let's just look at a couple more questions here. What if CBD oil makes no claims and is not an additive? Is it still illegal? If it's going into your body, yes. So I guess if somebody's putting CBD into a product and not advertising it, then it's less likely there's going to be an issue. But so I guess the bottle could say, hey, this is our new vitamin supplement, and it has CBD in it. It's just listed as one of the ingredients. And they don't say, hey, this has a medical benefit. I don't know that that's any different. I think the FDA would still be concerned. I think there's a blanket prohibition on edibles, no matter whether you're saying that it's a has a health benefit or not.
Well,
But I may be wrong on that.
And they're being aggressive about it.
Yeah.
So, I don't know that I would. I certainly wouldn't be comfortable if I were advising management about that. This is okay because I looked at the bottles in the supplement store, and they didn't, even though they said they had CBD in them, they didn't specifically say there was a health benefit. That's I think walking right up to the edge, and it's if you're there, you've probably decided you're taking a set of bigger risks as opposed to that's not where the thing ends. So let's do one more question.
Well, there's a quick one here. Is hemp CBD products also illegal according to the FDA? It doesn't matter where the CBD came from. The FDA doesn't care where the CBD came from, and they technically, I don't think, care what the amount of THC is in it. It still just can't be in an edible. This question I like, so let's do this as our last one. At what point does one of the two political parties run on a platform of federal legalization or decriminalization? The sell could be job creation, tax revenue, fighting the black market, protecting children, etc. I get that it would be a harder ideological sell on the Republican side, but there's so much money to be made. I think it's a great question. I don't know that in our current environment, running on that platform would actually work. I think it would be great. I think if we could get it, legalized and taken off the Schedule I, then it kind of makes all of this stuff go away. But if you're asking whether Elliot and I can predict whether somebody is going to run on a platform for that, I just don't know that we can. Although it's an interesting idea, and I would vote for them. I think, based on whatever other ideological things they are in their positions on other things, potentially it could sway me another way. But if somebody had this as part of their platform, I'd be all for it.
Again, I'm not a political analyst, but I'd be mildly surprised if it happens before 2032. So we're talking about the fourth election from right now.
Yeah.
At the federal level.
Yeah.
Using presidential election years. So we want to thank you all for joining us. We had a great audience today, and we appreciate your questions. We'll, again, if any more questions flow in, or if you want to send them to us directly by email, we'll be happy to respond to them. We will be sending out the slides to all of you who registered, and you will see additional content related to this topic appearing through our various channels. And lastly, watch for the next in our series of AML Voices. These are periodic pieces, so sometime in the spring we'll be doing one. We'll pick a topic, hopefully equally topical, and be bringing you expert information about it. Thank you again. And
I'll add one last thing. Within the questions here, if there's a topic that you would like us to address in a future webinar, whatever we might do, throw it into the questions here and we can take that under advisement, because we're always looking for what folks like you that are listening today would like to hear about, and we'd like to tackle that topic. So throw in as many questions as you want. We'll try to answer all of them. And again, maybe throw in some other topics for future webinars.
Great.
But thanks for joining us.
Yep, thank you very much.